Welcome, everyone. So nice to have you in class today. My name is Curry Sotner. I'm the Chief Learning Officer at the National Constitution Center and excited to see you all in class. And I am here with one of our top scholars, Tom Donnelly. And Tom, this is my favorite topic. We get to talk about the Fourth Amendment and I get to play, but wait a minute, Tom, but what about this? The entire 30 minutes we're gonna be in class. So how excited are you to talk about the Fourth Amendment?
I am very excited. Maybe not as excited as you, Curry, but I am very excited.
I will get you there. Now, students, a couple things. Number one, I don't have to be the only one asking questions. So if you have questions, put them in the chat. We love questions from our students. You can add in as many as you want. And lots of questions are good. And this is a really kind of complex topic with lots of layers. So what we're going to do is we're going to spend the first kind of part of this parsing out the words, because the Fourth Amendment is pretty straightforward in the amount of words it has, but they're really jammed and packed in there. So we're going to do a lot of clarity on what these words mean and definitions. And then we're going to go through some awesome storytelling of how did we get to the point where the founding generation puts this in the Constitution, and then what happens next. But I also promise you we'll have lots of hypotheticals today. So much to do, so little time. Hope you all have fun with this. Tom, you know we always have a million essential questions and guiding questions for this. But as we go through all these questions, it really boils down to this. It's always the question that we hear from students when they're talking about the government, be it police officers, be it the principal at their public school. The question always comes down to around the fourth, can they do that? So can you kind of just start unpacking the big ideas around the Fourth Amendment, and then we'll look at the words and start defining some of those terms.
Yeah, so the big idea behind the Fourth Amendment is that before the government can search your home or seize your property, it needs a good reason. So, I mean, when we think of something like the police officer needing to get a warrant, for instance, that's what's animating that idea. And so when we're thinking about the Fourth Amendment, it's asking questions like, can police officers stop me on the street? Can they search my car, my desk, my nightstand? Can they look at who I've called, where I've been, what I've written? And so many of these questions end up coming down to that same question is does the government have a good reason to search your home, seize your property, seize you? And we begin to see this, Curry. Should we turn to the Constitution's text?
Absolutely. You know we love to start there.
Yeah, and so here it is. It's really inspiring language. The right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrants shall issue but upon probable cause, supported by oath or affirmation, and particularly describing the place to be searched and the persons or things to be seized. Now, if we're looking at the text, there are a few things to note about it. We could really break down the text into a few different parts. First, it tells us what sorts of things are protected by the Fourth Amendment. So that's persons, houses, papers, and effects. What are effects in this context? It's our stuff. And what are those things protected against unreasonable searches and seizures by the government? And when we think of the government in this context, usually today, we're thinking about police officers. The Fourth Amendment is the provision that really affects many of our interactions with police officers. And then finally, the last part of the text we see here is the warrant requirement. And so this is just the idea that to get a warrant, the government has to show probable cause meaning certainly a certain level of suspicion of criminal activity to justify a particular search or a particular crime. It's a suspicion that attaches to a particular person, place, or item. But again, it's putting in place, it's connected to that big idea again, that if the government's gonna search our persons, houses, papers, or effects, it needs to have a good reason. And the warrant requirement requires police officers to go to a judge, to get some outside person to say, yes, there is a good reason here before searching or seizing someone's persons, houses, papers, or effects.
And every time we do this, I laugh because I basically read highlight the entire thing. But there's just so much in there. It's like a cornucopia of information in this. And so there's a lot of good words. And I think it's really, really interesting to kind of layer the ideas upon it. And when we get to the backstory, students, we'll really dive into why. Why were they so specific about having a different, a judge, a different group of the government to agree with the police officers in saying where they search, what they search, and what to be seized, and to have probable cause, and what that really means. So Tom, do you want to kind of dive into, before we tell the backstory, the different parts. Like maybe we look a little bit closer at what is the warrant requirement, what is probable cause, because even though you just kind of went through it, it's still sometimes a little vague and we need to hear it twice.
Sure. So, the warrant requirement, beginning with that, is that it places a restraint on the government anytime it searches or seizes a person or her property. And so true to a person's text, the Fourth Amendment's text, what we're looking for is a sort of it needs to be a search and seizure that's reasonable. And the warrant requirement requires police officers to clear that search or seizure in advance with a judge. So to get a warrant from a judge, the government has to show probable cause. It has to show that this search or this seizure is pretty reasonably related to a particular crime. And so, this isn't like this, the level that's required here isn't something like beyond a reasonable doubt, or even more likely than not. But there has to be some sort of reasonable connection between what the police officer wants to search or seize and the probability of their being connected to a crime of some sort. And so, Curry, it's another example of the way in which our system tries to divide power between different government officials to put checks in place to ensure that our rights are not getting abused.
And so, so that makes sense. It very much makes sense, especially when I'm thinking of somebody coming to somebody's house and serving a warrant and saying, we have the right to search your property, yada, yada, all those things. But then I think also about police officers and searching people on the street. And Tamar points out in the chat, I've seen video of people being stopped on the street and searched. So do they always have to have a warrant?
No. So generally speaking, police officers need a warrant, but there are many circumstances in which we say police officers do not need a warrant. And so one example would be, we have from a case called Terry versus Ohio, this idea that police officers can stop and frisk suspects if there's sort of a reasonable suspicion of a crime. And so there's sort of an exception there. There's exceptions in the context of automobile stops. And so in that context there, if a police officer pulls over an automobile, has probable cause that the automobile is somehow connected to a crime that's been committed, they could search that vehicle if they have probable cause, even without a warrant. And the way to think about this is, the warrant requirement, as the Supreme Court interprets the Fourth Amendment, is the default rule. There's a preference for there being a particularized warrant for all of the reasons we've already talked about. But there's also a recognition that in certain extenuating circumstances, it's just not possible to get a warrant. And so as a result of that, the Supreme Court over time has recognized exceptions to the warrant requirement in a variety of contexts where often time is of the essence. Maybe a suspect's going to flee. Maybe it's a really dangerous situation. Maybe the evidence is going to get flushed down the drain. A lot of contexts like that, we permit searches and seizures without a warrant. And so you're right, Curry. It's more complicated than to say that police officers always need a warrant. That's the preference within the law, but there are these exceptions to the warrant rule as well.
I think that's fascinating, and it was the students asking the question, so they're the brilliant ones. And so one of the questions in the chat was, that seems too expansive. It seems too flexible. And I want to hold that in our heads as we tell the story of how these ideas came to be in our Constitution. Because I almost want to ask ourselves, would the founding generation agree with you? Would they say that they put warrant requirement in there for a reason? Is it too flexible? I don't know. But I almost just, we love hypotheticals and we like to ponder. So I want us to ponder that and begin, Tom. And I'm like, Tom, story time. Tell us the story of Ritz of Assistance. I know that doesn't sound like a great bedtime story, but it's a really, really interesting one.
Yeah, so when we're thinking about the origins of the Fourth Amendment, it brings us to the story of James Otis. And so here we're in colonial Boston, the years 1761. It's 15 years before the Declaration of Independence. And there's a problem within the British Empire. The British Empire is fighting a war with France, and it needs money. The British Empire needs money. And so what it decides to do is it looks to the American colonies. It says, you know what? We have a lot of anti-smuggling laws on the books. We haven't really enforced them very much. But you know what? We could start enforcing them. The colonists have money. Maybe we could extract some money by beginning to enforce these anti-smuggling laws. And so as part of this action, King George III then uses his royal officials in the colonies to crack down on smugglers and tax evaders with what were called writs of assistance. So these writs of assistance gave royal officials free range to break into the homes of colonists to search for evidence anytime, anywhere, and for any reason. So this is the absolute opposite of the warrant that we see in the Fourth Amendment, which requires a statement of particularly what you're looking for. There's particularity to it, but with these writs of assistance, there's sort of broad authority given to the royal officials to rummage around looking for evidence of a crime. And so what this brings us to James Otis. So he's a prominent lawyer in Boston. He's a patriot, and he takes on the smugglers' cause. What's noted is like many of these smugglers, they're prominent Boston merchants. These aren't like some shady business dealers. These are many of the most prominent figures in Boston attacking these writs of assistance. And so James Otis goes to court, to the highest court in Massachusetts, and says, these writs of assistance are invalid. They're void under the British Constitution. We, the American colonists, we are entitled to all the rights of Englishmen. We are also entitled to all of the natural rights given to us by God and nature. These writs of assistance run against so many of these core protections. And so what's one of the key principles? Otis says that a man's house is his castle, and whilst he is quiet, he is as well guarded as a prince in his castle. And his main argument here about the writs of assistance is that the writs of assistance it's a power that places the liberty of every man in the hands of every petty officer. And so what Otis is concerned with here is just arbitrary actions, abusive actions taken by petty officials of the king. They're going to rummage around your house. They're going to look through your stuff. They're going to crack down your door. And it's just on their own whim. It's not by some broader rule of law. It's not by a particularized warrant. And this violates all of our most precious, so many of the precious things that we value, like the sanctity of the home, our own privacy, our protection from abusive actions taken by the government. So Otis gives this grand speech before the highest Massachusetts court, and he loses. So Otis loses his case, but this particular set of arguments really remains alive throughout American constitutional discourse for much of our history. Part of the reason is who's in the room while Otis is making these arguments? It's a young John Adams. John Adams reveres James Otis, and he would later go on to say that Otis's speech was the first scene of the first act of opposition to the arbitrary claims of Great Britain. Then and there, the child of independence was born. And this story has become so important over time that we've seen key Supreme Court justices draw on it when interpreting the Fourth Amendment. Justice Louis Brandeis draws on it in Olmstead versus United States, which we'll talk about in a little bit, and Chief Justice John Roberts, in a case just a few years ago, Riley versus California, once again recounts the Otis story as a key foundation for the Fourth Amendment. Again, it reinforces that big idea that in America, under the Fourth Amendment, if the government wants to search or seize our stuff, us, our house, our effects, anything, it needs a good reason.
I think that story is so amazingly powerful. I always forget that he didn't win. Because you know how much of a huge impact it had on the founding generation and kind of moves forward. Now they get the Fourth Amendment, it's added to the Constitution with the Bill of Rights. It's so key, and that's why the words are so strong and so specific in there. But how has the court kind of defined it over time? Should we begin to kind of look at the main cases, which I always love because they all wind up being phone cases. But should we start to look at how our court starts to apply the Fourth Amendment and where we see the real testing of the Fourth Amendment and changes of the Fourth Amendment begin to happen in our country?
Yeah, that sounds great.
Great. So let's jump in. You want to do Olmstead? Okay,
so it's Olmstead versus United States. It's 1928. So, what's happening here is it took place during the height of Prohibition. This is the war on alcohol. And during this time, the government's using wiretaps on the phones of suspects in order to enforce its prohibition laws. In other words, to catch people that they thought were selling alcohol illegally. And so in Olmstead, federal officials were investigating Roy Olmstead for running basically an illegal liquor business. And so without a judicial warrant, they install wiretaps on the phone lines leading to the office of the suspected illegal business, to Olmstead's home, to the other suspects there. And, a wiretap here, what's required is literally they had to sort of go into the road, into the public streets or in the basement of the building and really physically tap the wires of the phone lines. And so, well, as the government's doing this, they're not going into Olmsted's office, they're not going into Olmsted's home, but they are sort of tapping into the lines of the phone communications in the public streets and in the basement of these office buildings. And so, here, this allows the government then to listen into the suspect's phone conversations, and the agents find evidence that Olmsted was selling liquor illegally. So he's arrested, he's tried, and Olmsted argues, a very simple argument. He says, this violates my Fourth Amendment rights. This violates my Fourth Amendment rights. What could be clearer here than you're listening in on my phone conversations? These are things that are mine. You're tapping into these phone lines. Clearly, this has to violate the Fourth Amendment. And so what does the Supreme Court say here? So the Supreme Court, it's a very divided opinion. It's a 5-4 decision. So the justices thought that this was a hard case. On the majority opinions written by Chief Justice William Howard Taft. So this is Taft's time after he's president of the United States. He finally gets the job he always wanted, Chief Justice of the United States. So it's Taft in the majority. And then the dissent is written by Justice Louis Brandeis. So it's two great figures in American constitutional history. What Chief Justice Taft says is that, Mr. Olmsted, you're wrong. If we're looking at the Fourth Amendment, how have we interpreted it over time? We've connected it to physical things, to stuff. So if you look at the text of the Fourth Amendment, it seems to speak of physical material things, like our bodies, our houses, our papers, our effects. Here, all the government's doing is listening in on communications. It's tapping phone lines. When they tapped these phone lines, they didn't walk onto Olmsted's property. They tapped into these phone lines under public streets, in the basement of the office building, which did not belong to Olmsted. And so here, simply speaking, the government, there is no Fourth Amendment violation, no warrant requirement. And if you're really looking to boil down to what is Taft's rule here, it's that if there's no physical trespass, then there's no Fourth Amendment violation. So it's really connecting the Fourth Amendment and its protections to property rights, to property, to tangible things. But we see here a really powerful dissent by Justice Louis Brandeis. And so as Brandeis in his dissent, what he says is that, look at the founding generation, look at what they care about. And what we have to do here when interpreting the Fourth Amendment is we have to apply those old principles to new technologies. And this means we have to have a really clear goal in place. And that's to protect at least as much property, as much privacy now as the founding generation protected back at the founding. And so Brandeis really has some really prescient words about what we need to be concerned about when applying the Fourth Amendment to new technology. He says progress of science and espionage is not likely to stop with wiretapping. Ways may someday be developed by which the government, without physically intruding into the home, may extract secret records and introduce them into court. This is, in a way, Louis Brandeis is anticipating cloud computing. The idea that someday we'll be able to put all of our stuff out there somewhere in the universe and the government can access it without rummaging around our house and going through our drawers. And so Brandeis also says, at the time of the framing, a far smaller intrusion, the general warrants that sparked the American Revolution, he's talking about James Otis, were held to be unconscionable violations of liberty. Can it be that the Constitution does not afford protections against similar invasions in light of new technology? In other words, again, Brandeis is challenging the Supreme Court to go beyond old categories and ensure that they're applying the traditional principles of the Fourth Amendment to new technologies in a way that protects privacy at least as much as the founding generation envisioned.
So that's just a very intelligent lesson to pull out of this too. Look at the principle. Look at the idea that they were writing into it, the big idea that they were writing into that amendment, and saying, is it applied the same? Is it being applied appropriately, even though the world is changing and shifting underneath it? Which last Wednesday, when I was missing class with you guys, I was actually in a lecture on the internet, the age of the internet, and data, and looking and understanding that. I'm not sure I processed through that or understand it yet, but it's really fascinating that it was talking more the way Brandeis is talking about it and what we can understand from privacy, even outside the government setting, and where the government can and can't interplay with that. Now, talking about technology and advancement in technology, let's go to the phone booth, which some of our students might not actually recognize this thing. But students, if you don't know what it is, that's the phone booth, and they used to exist all over the place. In London, they were all red, right, Tom? For like a period of time, there were those red phone booths. So you could find them, you could pick up the phone. I always had to put a quarter in, but there was different amounts that you would put in, and you would close the door. So tell us how this case kind of shifts and changes this idea of reasonable expectation of privacy and what that means.
Yeah, so Olmstead, again, it's giving us a rule that says the Fourth Amendment's it's connected to places, it's connected to physical things like that. Katz versus the United States, returns to these sorts of questions in the context of Charles Katz. So Charles Katz, he's suspected of transmitting illegal gambling information over the phone to clients in other states. So federal agents, his operation is him sitting in a public phone booth, shutting the door, and calling people in other states. And so the government ends up, suspecting Katz of this illegal activity, and they decide we're going to put an eavesdropping device on the phone booth. So, and so we can listen in on the conversation. And based on the recordings on that, his end of the conversation, Katz is convicted for illegal gambling. Katz then goes to court and he makes a similar argument to what Olmstead had to say. And that's that the Fourth Amendment, the government here violates the Fourth Amendment by listening in on his phone conversation. The government in reply says, no way, just read Olmstead. Olmstead already answered this question. We should win. And the Supreme Court responds, no, not so fast, government. Actually, we're going to reconsider how we approach the Fourth Amendment. And in a 7-1 decision written by Justice Potter Stewart, the court ultimately agrees with Charles Katz. And so Justice Stewart, in his majority opinion, has a famous quote where he says the Fourth Amendment protects people, not places. And so here the court rules that Katz was entitled to the Fourth Amendment protection for his conversations in this context, and that a physical intrusion into the area occupied was unnecessary to bring the Fourth Amendment into play. And so the court reasons that the Fourth Amendment protections, they're not limited to an individual's property. And so although the phone booth is a public space rather than someone's private property, individuals have strong expectations of privacy when they go into the phone booth. And one of the things the court highlights, Curry, is exactly what you said. How do we know this as to Katz? How do we know this to everyone else? It's that the phone booth itself has this door. And so when we end up closing that door, we're then creating our own space of privacy, and the government can't enter it without, the Fourth Amendment being implicated. And so here, Katz wins. We also have a very influential concurring opinion by Justice John Marshall Harlan. And this is a reminder, read all of the opinions in a case. Sometimes the concurrences and dissents end up being the most important. And here, Justice John Marshall Harlan gives us a way of thinking about how to analyze the Fourth Amendment and reasonable expectations of privacy. And under this Katz test from Harlan, what Harlan has us ask are two separate questions. Did the individual have a subjective expectation of privacy? Did the individual expect this to be a situation where it was going to be something private? And we know this in the Katz case because he closed the door of the phone booth. And second, was the expectation of privacy one that society would recognize as reasonable? So that's sort of an objective question. Was it reasonable for him to even have expected for privacy to attach in this situation? And so in the end, Harlan gives us this test of reasonable expectation of privacy to give us a way of understanding whether or not the government has conducted a search that implicates the Fourth Amendment.
And that is, and I love this. The Harlans always come out with some good opinions, just as a general. But I also find it helps to define these very kind of subjective words and saying like, okay, look at yourself. Did they have a reasonable expectation? Okay, look at society. Would they agree upon that? And there's a lot that comes into play here when we're talking about police and privacy and suspects and criminals as well. And we're going to get into that a little bit. I know there's some students that have some questions about, that process and how it works, and then how does the system work around that. But it really kind of helps define what these words mean and how do we put a definition on something that can sometimes feel super, super vague. The next case that we're looking at is one of my favorites, and it really does go to the hypothetical that we're going to try to answer for ourselves. I'm going to just flash us to the hypothetical first so everybody can start pondering it. And then, Tom, I'd love you to tell us the facts and the history of the case. So students, the hypothetical on this one is general hypothetical. You guys can answer in the chat now. We'll do it again afterwards. But so far, understanding the Olmstead case and then looking at the Katz case, hypothetical is, can the government track you 24 hours a day, 7 days a week for an entire month using your cell phone data for location information. So if you didn't know, your cell phones are pinging all the time, and I don't even have a house phone anymore. So most of the phones that most people have are constantly pinging off the cell towers. But what that does is it tells the cell towers and the companies where I am at all times. And so if a police officer wanted to, and had the right to, they could go in and they could watch me. So the question is, can they do that? Back to our original statement in question. We're going to dive into the case, Carpenter versus the United States in 2018, that really unpacks this question. But if you want to start now, which I think you're already doing, you can answer in the chat now what you think on this. Can the government track you 24 hours a day, 7 days a week for an entire month using your cell phone data and location information? Yes, no, or I don't know, I need more information, or you can always do a maybe. It depends. As Tom always says, it depends is an important option as well. So go ahead and put it in. Tom, tell us about this case and what actually happened.
Yeah, so in Carpenter, the police officers arrest 4 men in a string of armed robberies. So it's an armed robbery case. One of these men confesses. He gives his cell phone to the FBI. He also gave the agents the phone numbers for many of his accomplices. So then the FBI uses this information in the suspect's call log to get the cell phone records of many of the suspects from their phone companies. And importantly, the government doesn't get a warrant before getting this information. Instead, they request this data through a national law called the Stored Communications Act. And by using this law, the government only had to say that the cell phone records were relevant to a given investigation. So this is a level of proof below something like probable cause. So they're relying on this particular law. The police eventually arrest Timothy Carpenter, and he's convicted and sentenced to 116 years in prison. And Carpenter asks the question that we ask at the beginning is, may the government do this? Can they do this without a warrant? Doesn't this violate the Fourth Amendment? And the Supreme Court ultimately, in a 5-4 decision, it's another really closely divided case. And in a 5-4 decision authored by Chief Justice John Roberts, rules that the practice of acquiring cell phone location information from cell phone companies is a Fourth Amendment search. So it does, generally speaking, require the government to get a warrant. And so the reason is why. So, I mean, part of the reason this is a hard case is because there are other sorts of decisions on the books that seem to point in the other direction. So these cases in the 1970s, United States versus Miller and Smith versus Maryland, that say that, if you give your stuff over to a company, that you then give up all of your reasonable expectations of privacy in that stuff. And therefore, if the government wants it, it doesn't need a warrant to get it. Instead, it can go to those companies and get it, for instance, in the context of bank records or even phone records, a log of the phone numbers you call. The Supreme Court said it's called the third-party doctrine, that once you decide to give over those sorts of records to those companies, the government can then get that information without requiring a warrant. And Carpenter versus United States required the Supreme Court to say, are we going to apply that third-party doctrine to this context where the government's looking for information to sort of cell phone information location data? Are we going to apply it in this context? And Chief Justice Roberts says, no, I am not going to extend the third-party doctrine, because in the end, if the government's going and getting this information without a warrant, it violates a person's legitimate expectation of privacy in the record of his physical movements. And so it's the Supreme Court relying on Katz here to say, if we look at what do these records of your movements do, they could provide just a ton of information about you. There's some great quotes from Chief Justice Roberts explaining his reasoning here. So he said, for the court, access to historical cell site records violates that reasonable expectation of privacy because it is a, quote, sweeping mode of surveillance that gives the government the power of near perfect surveillance as if it had attached an ankle monitor to the phone user. The surveillance is detailed, encyclopedic, and effortlessly compiled. It provides an all-encompassing record of the holder's whereabouts. As a result, what we're going to say is, if government, you want that information that really gives a very full portrait of what someone's doing over a period of time, generally speaking, you need to go get a warrant.
And that was always my question in this case. And thank you so much for explaining it. Like, why didn't they just go get a warrant in the first place? And thank you for explaining that these prior cases, we're talking about these public companies that had public information. You had already given your data over. Why did they have to? It already existed. but this overwhelming ability for, if they could do that, for the government to constantly monitor you, cross the threshold. And then it brings us to, so many other cases that we could look at and examine and say, can the government use public data in a way that solves cases, but also at the same time puts too much oversight of the government onto the people? And that merging between government information and public information, and where are the lines drawn? It's just something we're going to be talking about nonstop in years and years to come as more and more technology, like Brandon said, goes into the cloud. And that's exactly how we said it, but the general idea.
Well, and here the dissenters drawn some of what you're saying there, Curry, which is the dissents here. Part of what they say is the Fourth Amendment, it has old principles. Technology moves really, really quickly. The line drawing here, the rules that we want involved are really, really difficult. Here, what we have is a law passed by Congress, which is meant to strike the right balance between sort of keeping up with technology, giving government what it needs to investigate new crimes, but also protecting privacy to a certain extent. And one of the things the dissent says is, why don't we defer to Congress in this situation? They thought the Stored Communications Act was enough. We're just going to say, maybe Congress has the better idea here. Maybe we don't have the best ideas. So whether it's deference to Congress or whether it's applying that old third party doctrine to this situation, the dissenters think that the majority got it wrong. And then in this circumstance, the government should be able to do what it did.
Awesome. And you're right. It is still 5-4. Okay. So I think this is a fantastic class. We got our big ideas. We go back to the hypothetical, which the hypothetical is no, get a warrant, and kind of do that work. What I'm going to do now is I'm going to stop the class share. Students, if you have to jump off, we understand you're on tight school schedules, jump off. If not, we're going to save the next round for questions for Tom on warrants, policing, and things in general, which we have about 5 in the chat. So I will go through there, but thank you so much, students. Tom, thank you so much for walking through this history and these big cases.
No problem. Thanks, everyone.